Hello, my name is attorney Masa Sam Foray. I am owner and founder of the Foray firm with offices in Chicago and in Houston, and I am back again today to answer all of your Illinois family law matters. So today's question is, can a grandparent seek custody? So first of all, let me just make sure that I clarify. The word custody was actually stricken from the statutes. It was stricken from the IMDMA a couple of years ago. So now in lieu of custody, the word that we actually use in Illinois is allocation of parental responsibilities. And in another video that you can scroll through and find, I actually go through a bit of the differences and the nuances between what custody was and what allocation of parental responsibilities now is. But in any event, if you're in court and you hear somebody saying the allocation or the allocation judgment, or using the acronym the APR, it is what most people would associate with the word custody. So what the question is really asking is, can grandparents seek allocation of parental responsibility? So the answer is yes. Not only can grandparents, who are non-biological parents, seek the APR of minor children, but any non-biological parent can seek the allocation of parental responsibilities of minor children. Now think about that. Think about what I just said. Any non-biological parent. That means that theoretically, I, as a non-biological parent to your children, could seek allocation of parental responsibilities for your children, but only in narrow and limited circumstances. I would first have to show that those children were, number one, not in the custody or the possession or control of a biological parent. And then I would also have to show that you had voluntarily and indefinitely relinquished that control. So a good hypothetical of that, and one that comes up very, very commonly in our practice, is that you'll have, let's say, a mother who might be a young mother. Perhaps she was a young mother, a teen mother, 19 or 20 when she had her children. And perhaps after she had her children, she felt like she needed some time to get herself together. This is a scenario that we see quite often as family law attorneys. A mother who will turn her children over to her own mother or turn her children over to her own sister and say, hey, can you just keep these kids while I get myself together? While, I want to, just have some time to myself and get my thoughts together. But there's no time period. It's an indefinite period of time. It was a voluntary relinquishment. It's not as if Department of Child and Family Services came in and forced her to turn the children over. There's no court order for guardianship or custody that forced her to turn the children over. In those circumstances where there is a voluntary and indefinite relinquishment of the custody of the minor children, and if the court determines, once again, that it is in the best interest of the minor children to be with the person who is petitioning to have the allocation of the children, then in those circumstances, yes, that person would have standing. And then that person, once they had established that they had standing to seek custody, the court would do a general best interest analysis. And that non-biological parent would be, in this circumstance, the petitioner. Biological mother would be the respondent. And just like any other case where there is one side versus the other side, the court would just determine whether or not it was in the best interest of the minor children to stay with the petitioner, or in our question, hypothetical, the grandparent, versus going back with the mother. So you can imagine that this is not something that courts do on a regular basis. Public policy dictates that biological parents are presumed to be the best person to raise children. It is the presumption that biological parents are always in a better position and that their rights trump that of any other individual. But in circumstances like this, where there again has been a voluntary and indefinite relinquishment of the custody of the minor children, somebody else, a non-biological parent, whether related by blood, like a grandparent, or not related by blood, could definitely get standing and seek to have the custody or the APR of the minor children. So if you have any questions about this scenario, if this is something that you are concerned about because of actions you have taken by allowing your children to stay with a family member temporarily, and they have subsequently filed a motion in the Domestic Relations Division, definitely reach out to a trusted family law attorney to make sure that your rights as a biological parent are protected and remain intact. I hope that this has been helpful.